Listen so that he understands. Well, Hector asked me to introduce Professor Shapiro. I'm Gustavo Vega, the director of the Center for International Studies in Mexico. I work on Attorney and alma mater. We invited that Shapiro. He had 2 times at Conference. He was very generous in coming to give us a series of lectures on political philosophy, political theory 2 years ago, and that led to a decision in the collegiate to translate a book on the basis of which he gave his lectures. And now the book has been translated, Moral Basis of Politics, into Spanish, and he came back to participate in a roundtable discussion about that. He's a well-known, as you know, political scientist in the United States, one of the most distinguished and recognized. I would say not only in the United States, but also worldwide. His books on the state of democratic theory, pathologies of rational choice, his book on the moral basis of politics has been translated to, you were telling me, 14, 15 languages, among which are Kurdish, Indonesian, etc. So it must have some importance and interest in that. And when I knew he was coming, Hector and I participated in a conference that Professor Shapiro organized at Yale on Mexican election. I thought that there might be an interest in having Professor Shapiro here. Hector said yes, and he agreed to talk about this issue, which is, as you know, very hot at the present time in Mexico. But hot in the sense that the politics of abortion now has become an issue in Mexico. So probably it would be an interesting thing to hear how it has developed in the United States, what the kind of politics, constitutional politics on the topic, and probably we can learn something about that from there. So,
yes. Thank you, Gustavo. Well, I would just like to welcome Professor Shapiro here at the Institute. As you know, the topic you are proposing to speak about today is, as Gustavo was saying, very relevant now at this moment in Mexico. You may know here in the Mexico City, the legislature passed last year a bill legalizing abortion here in Mexico City, and this law has been challenged before our Supreme Court, and the decision is still pending, but the court has started to organize public hearings about the topic. This is something new for us, and they are going to hear different opinions. And well, we hope that the decision is right in the sense that it won't spark more controversy, or more or less can satisfy, but not completely, but more or less the ideas that of the majoritarian views in Mexican society. So welcome here at the Institute, and we are very eager to hear your comments about politics of abortion in the United States. Thank you.
Okay, thank you very much for inviting me, and I was actually completely unaware that this was a timely subject in Mexico when I agreed to do this. I had just finished revising my casebook on the abortion decisions of the U.S. Supreme Court, because last summer they handed down a new decision in the matter of partial birth abortion, and I'll get to that in a minute. So that's why I've been working on it recently, and I proposed it as a subject to talk about here today. And so I should say I'm embarrassingly ignorant of the debate that's gone on in Mexico, and particularly how the issue has become before the Supreme Court. So I'm eager to learn about that side of it, but I can tell you about the American process and history. So last summer, the new Supreme Court handed down a decision called Gonzalez versus Carhart, in which they upheld a federal statute that had outlawed the so-called process of partial birth abortion. Partial birth abortion is a controversial abortion procedure in the U.S. where in certain types of abortion, the fetus is partly delivered in the process of performing an abortion. Conservative social groups, religious groups, and others think it's an especially objectionable procedure because of two reasons. One is that it's a very bloody, gory procedure, and they have put on if you go and look on the internet, you can find very graphic pictures of it and descriptions of it. But the other is, I think that it raises questions in their mind about infanticide, about whether this is very close to actually delivering the child in the process of aborting the child. And so the people who are morally outraged by abortion find it in a particularly egregious, objectionable abortion procedure. So what was interesting about this decision, and I'll come back and say more about it in a little while, of course, is that it was a reversal of a decision 7 years earlier in Stenberg versus Carhart on exactly the same subject. In Stenberg versus Carhart in 2007, we had 5 justices supporting a Nebraska statute which had supporting the striking down of a Nebraska statute that had outlawed partial birth abortion. The state of Nebraska had passed a statute outlawing it, and it came up before the Supreme Court, and the court said, no, the state of Nebraska cannot outlaw partial birth abortion. And the reason they gave was that they said outlawing partial birth abortion puts an undue burden on women. I'll have more to say about this idea of what is an undue burden, but the notion that I want to explain it right now. I'll come back and explain it in a little bit. But the Supreme Court had in earlier cases affirmed this idea that states can regulate abortions, but not in ways that place undue burdens on women. And so in 2000, the court had said, well, whatever else undue burden means, it means that in a situation where it's legitimate for a woman to have an abortion, a woman shouldn't be able to undergo a less safe procedure if a more safe one is available. That if you make a woman undergo a less safe procedure where the more safe procedure is available, this puts an undue burden upon her. And there had been testimony in the courts below that partial birth abortions in some circumstances was the safest procedure. So the court had struck down as I said, by a majority of 5-4, this decision. But of course, between 2000 and 2007, Justice Rehnquist died and was replaced by Chief Justice John Roberts. Of course, that didn't change anything because Rehnquist and Roberts were on the same side of this question. But Sandra Day O'Connor died, and she was replaced by Samuel Alito, and that meant there were now 5 votes to 4 the other way. And so what had happened in the interim, after the court had struck down the Nebraska statute, Congress enacted a similar version. The federal government legislature enacted basically the same statute as the Nebraska statute. And the new court, considering it, upheld it. So this was essentially the court reversing itself. So that's where we are today. And I'll have a little bit more at the end of my remarks to say about where we are today. But I think it will be helpful now to go back look at the history of abortion jurisprudence in the U.S. from the beginning, with a focus on 3 main questions. First, the focus on what was decided, the substance of abortion law as regulated by the courts in the U.S. Second, how it was decided, the processes by which the court operates that illustrate how it works to sustain its legitimacy within the political system, and also why it was decided, what the basis of the woman's constitutional right to abortion is. There was initially an argument about privacy. There's also an argument about equality, and finally the notion of stare decisis, which I'll come to a little bit later. So I'm going to organize my remarks about the history of Supreme Court's abortion jurisprudence around these three topics: what, how, and why. Okay, and then we'll come to the decision. Come back to the present and say, where are we now, and what does this tell us about the way the Supreme Court operates in highly contested and controversial matters? So, if we look at what did the Supreme Court actually decide about abortion, the two key ideas that we're going to have to get control of are the 3-trimester test, which I'll explain in a minute, versus this idea of undue burden, which I've already alluded to, that the court articulated in 1992. But let's first start with the 3-trimester test. If you want to understand the history of U.S. abortion jurisprudence, you actually have to go back to 1965 to a case that had nothing to do with abortion. This was the case called Griswold versus Connecticut. I should just say, all along where I put these justices up, I have in brackets the president who appointed them, and I'll talk a little bit more about the relationship between politics on the court and the political process en passant, and that's why it will sometimes be useful to know, that Eisenhower appointed Earl Warren, that Roosevelt appointed Douglas, and so on. So that's why those names are there. So Griswold versus Connecticut had nothing to do with abortion. It was about contraception. It was an old Connecticut statute that had been on the books since 1905, which forbade physicians from giving married couples advice about contraception. And the court struck this down, even though it hadn't been enforced for many decades. The court struck this down, and why this opinion was important was that they invoked a constitutional right to privacy. They invoked a constitutional right to the privacy of the marital relationship, and said that this Connecticut statute interfered with that privacy. This would become an immensely controversial proposition later because the word privacy appears nowhere in the U.S. Constitution. So there would be, over the coming decades after 1965, there would be huge arguments about what in the Constitution actually entails the idea of privacy. But in any case, Griswold versus Connecticut established the idea as a matter of Supreme Court jurisprudence that there is a constitutionally guaranteed right to privacy, and this Connecticut statute outlawing physicians from discussing contraception with married couples violates that right to privacy, and the Connecticut statute was struck down. 7 years later, the court took up the same issue and said, well, it's not really the family privacy that's at issue here. It's the privacy of the individual. And it was this case, Eisenstadt versus Baird, said that you don't have to be a married couple in order to have this right to privacy. This right attaches to individuals. So that this sort of entrenched and solidified this idea of privacy as a right that people have, that is constitutionally guaranteed, even though it's not written anywhere in the Constitution, and was said to be implicated in the due process clause of the Fifth Amendment, in various other parts of the Constitution as well. So by 1972, we had this entrenched individual right to privacy recognized in American constitutional law. The following year, there was a case in Texas of a statute prohibiting abortion that was litigated all the way up to the Supreme Court and has the famous name of Roe versus Wade. And this is the beginning of explicit abortion jurisprudence by the U.S. Supreme Court. A majority of 7-2 upheld the idea of abortion, building on this notion of privacy that had been established in Griswold and Eisenstadt before. And the court said there is indeed a constitutional right to privacy, to the women's right to privacy in this case, and it extends to the private decision to have an abortion. It was elaborated by Justice Blackmun, a Nixon appointee, who wrote the opinion of the court and who thought it was his most important decision of his lifetime. And just as was mentioned in the opening remarks today, Blackmun hoped that this would settle the question for all time. He thought by the court stepping in and giving an extremely clear statement of what the constitutional right to abortion was, that the question would be settled. And so he articulated this 3-trimester test, which I put up here, that I took straight out of the opinion. And basically it says during the first, up to the end of the first trimester, the abortion decision is left in the hands of the medical judgment of the pregnant woman's attending physician, i.e., the state of Texas or no other state can in any way regulate abortion up to approximately the end of the first trimester. During the second trimester, the state, in promoting its interest in the health of the mother, notice, in promoting the interest in the health of the mother, nothing else, may, if it chooses, regulate abortion in ways that are reasonably related to maternal health. That is an important statement because until very recently, we should remember that almost all regulation of abortion had nothing to do with the fetus. It had to do with the health of the woman because abortions were dangerous and could be harmful to women. But one of the things that had changed as a result of medical advances by 1973 was there were greater risks in carrying a fetus to term than in having the child than there were to abortion. But so during the second trimester, this is basically until at the point of viability. In those days, a fetus was viable more or less at the end of the second semester. Viable meaning it could survive outside of the womb. States could only regulate abortion in order to promote the health of the woman. No other reason. Once the fetus becomes viable, the state, in the interest of promoting its interest in the potentiality of human life, can regulate abortion. And the last part has gotten chopped off, unfortunately. But it could only regulate abortion if there were an exception for the life and health of the mother. And health there was defined extremely broadly to include psychological health. So in effect, it meant that there was abortion on demand because there would always be a physician who would be willing to say that it was in the emotional health or psychological health of the woman to be able to have an abortion. So even in this post-viability stage, while the state had an interest in promoting potential human life, not just an interest in the health of the mother, it could only vindicate that interest if there was an exception for the life and the health of the mother. The life and health of the mother trumped, if you like, during the third trimester. Nonetheless, it was thought to be important, and we'll see later it was important because Roe did recognize that after the point of viability, the state of Texas had an interest in potential life, in vindicating the potential life, even if in practice this would be trumped by the life or health of the mother. So that's where abortion stood in 1973. As I said, there was a huge majority for it on the Supreme Court, including the Chief Justice Warren Burger then. But Rehnquist, who was not in those days the Chief Justice, was a dissenter, and Byron White, a Kennedy appointee, was the other dissenting opinion. But otherwise, Justice Blackmun managed to build a big majority for the creation of this right, woman's right to an abortion. But Blackmun's prediction was completely wrong about ending the controversy. On the contrary, Roe versus Wade was like pouring gasoline on a fire in terms of the politics of abortion in the United States. It became immensely controversial from the beginning. It galvanized the pro-life so-called constituency into action to try and get this changed, and it greatly politicized appointments to the Supreme Court because religious conservatives and others sought to have an influence on it. However, because the pro-choice majority was so big, it would take a long time and a big change in American politics before it began to erode. And in fact, it didn't come until the late 1980s in this case, Webster versus Reproductive Health Services. This was a case that came down when Rehnquist was now Chief Justice, and there were 5 justices for upholding some abortion regulations. But what was important about this decision was that in the course of defending this view, the majority opinion, that the state has an interest in potential life before the point of viability. And by saying that the state has an interest in potential life before the point of viability, that appeared to completely destroy this logic, because previously in Roe they had said the state's interest in promoting potential human life occurs only after the point of viability. So the implication was in Webster, well, if they've said the state has an interest before the point of viability, they've really thrown out Roe versus Wade. And so, interestingly, you got 2 separate opinions. One furious opinion by Blackmun saying that you've completely destroyed the most important decision of my life on the court. You're pretending that you haven't repealed versus Roe, but we all know you've repealed versus Roe. You're just not saying so. You haven't come out and admitted it. And then Scalia, who was in the majority for the results of overturning this at least upholding this particular abortion regulation, Scalia said exactly the same thing. He said, it's obvious that we've gotten rid of Roe versus Wade. Why don't we say so? Why don't we admit it? Why don't we pretend that this is a narrow decision about one regulation of abortion? We have clearly junked the trimester test in Roe. Roe versus Wade is dead, but people don't realize it. We're just pretending. So Blackmun and Scalia both agreed that Webster essentially was the beginning of the end of Roe. And Blackmun was furious about it, and and Scalia was angry that the court wasn't moving more rapidly and just scrapping the whole Roe versus Wade decision and repealing its own position of 1973. Well, if you think about what effect this would have on politics outside the court, you can imagine it just fueled all the fights about abortion, because now everybody felt very insecure about what the politics of what the court was actually going to do. On the one hand, defenders of the right to abortion, Roe versus Wade, were extremely alarmed that Blackmun might be right and that Scalia might be right, and that this really was the end of the beginning, if not the beginning of the end, of abortion rights. On the other hand, the pro-life people were very energized by this, because they thought, we've got our foot in the door, we just have to keep pushing now, and we're going to get rid of abortion. So it became immensely politicized in 1989, 1990, and in the run-up to the 1992 presidential election, where Democrats, in particular, ran on the proposal, Bill Clinton and others were running on the proposal that if elected, they would ensure that Congress would pass a law to reinstate Roe v. Wade, to reinstate the protection, because Congress had, to this time, never been involved in anything to do with abortion. All abortion regulation had been state regulation. This may have some analogies to Mexico, where this is a city ordinance that's being challenged. The federal government, the federal legislature had never been involved in abortion. But now, because everything seemed so uncertain, the Democrats, as I said, ran on a platform in which they said that if they won in the 92 election, they would pass a bill that would reinstate Roe versus Wade. And so this was the abortion politics was just incredibly what's the word? It was galvanized on all sides, and it was a very hot subject in the run-up to the 92 election. But before we got there, in the summer of 92, the court handed down a new decision that took the wind out of the sails of all of the political campaigning, at least on the Democratic and pro-choice sides, where we now had a 5-person majority upholding a Pennsylvania abortion regulation. And it turned out that there was now a 3-person centrist group on the court: Sandra Day O'Connor, who had been appointed by Ronald Reagan, Kennedy, who had also been appointed by Reagan, and John Souter, who had been appointed by Herbert Walker Bush, the first Bush. And they said, no, there is in fact a constitutional right to abortion. We didn't get rid of it in Webster. What we said was that there is this undue burden standard. What is an undue burden? How do we know an undue burden when we run into it? They said, well, a finding of undue burden is shorthand for the conclusion that a state regulation has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. So before the point of viability, women cannot have an undue burden imposed upon them in having an abortion. So in Casey,
a new burden here would be a prohibition for her to have the abortion, for example?
So, yeah, let me give you some examples. In Casey, the court took up the question, should a woman be required to tell her husband before she has an abortion, which had been one of the things in the Pennsylvania statute. And the court said, no, she should not, because that sometimes men become violent and intimidate women and so on. This places an undue burden on women to require women to. Okay, so any proposed regulation of abortion that was judged to put an undue burden on women would be struck down. On the other hand, they said, should a child be required to tell her parents before having an abortion? And they said, yes, a child can be required to tell her parents, provided there's a judicial bypass, that if the child's afraid of the parent, they can go to a judge, I don't know how realistic that is, and get permission to have an abortion. Okay, so what the court said was this idea of undue burden means that we have a very different approach now to abortion, which is just like the rights balancing that courts do all the time. If you think about other areas, you know, we have We have a constitutional right to freedom of association, and we also have the Equal Protection Clause. Well, what happens when golf clubs say we don't want to admit blacks, or we don't want to admit women, and appeal to the constitutional right to freedom of association, but then litigants come in and make the case, yes, but important jobs get given away in these clubs and people's advancement at work is, there's an ongoing network in these clubs, so it violates equal protection. And then the court has to do a kind of balancing. Well, yes, freedom of association says women or blacks could be excluded from a club. Equal protection says no, they can't be excluded from the club. And we have to do a balancing. We have to decide what are the circumstances in which the one prevails, what are the circumstances in which the other prevails. Courts do that all the time. So by moving to this undue burden standard, they said, yes, contra Roe, back in Webster, we did say states have an interest in potential life from the beginning, before the point of viability. But now we're also saying women have a right not to have to experience undue burdens. It's just like a rights balancing problem. They're two conflicting rights, and we have to think about what are the circumstances in which the one right prevails, what are the circumstances in which the other right prevails. So the conservatives on the court were furious. Scalia writes a fuming dissenting opinion, which is also signed by Thomas and Rehnquist and White, saying, this is crazy. This is just going to create endless litigation. Nobody knows what undue burden is. There's no principled basis for saying a husband doesn't have to be told by his wife, but a parent does have to be told by the child. This is just madness. And we should have gotten rid of abortion completely. On the other hand, Blackmun was greatly relieved because it seemed like not everything was lost. And the wind went out of the sails of trying to get legislation through Congress. And when President Clinton was elected in 1992, nothing happened. The issue sort of went away in terms of American politics. Because another thing, just to go back to Casey, of course, is that you had, apart from Blackmun and, Stevens was then pretty young still too, you had a young majority on the court. And then, of course, President Clinton came along in 1992. Blackmun retired, but he was replaced by, got to keep on my, Clinton replaced him with Ginsburg, and Breyer came onto the court as well, replacing, who does Breyer replace? Where do we go? White. Okay. Breyer replaces White. So you get, because White had been on the other side, you actually go, Blackmun being replaced by Ginsburg is a wash, but Breyer replacing White means you now have 6 in support of Roe versus Wade after President Clinton comes into office and replaces these 2 justices. So the court then leaves the abortion question alone for a long time, for 8 years. Why have I got the 2007 first? We want that one. Okay. For 8 years, the court leaves the question alone until this partial birth abortion comes along. And this is the first test of this undue burden standard that they confront. And as I said, there were now 6 votes in support of the undue burden standard because Ginsburg and Breyer had been added to the court. So you might say, well, then why is this a 5-4 decision? And the answer is Kennedy flips. Kennedy had been part of the group that created the undue burden standard, but as applied to the partial birth abortion question, he said no. It's very unclear from the opinions that he writes why he said no, whether he's changed his mind about the undue burden standard or he just thought it didn't apply in this case. But it probably is the latter because Scalia, Thomas, and Rehnquist all signed a dissenting opinion saying this undue burden standard was nonsense when we enacted it in 1992. It's still nonsense. We should get rid of this completely and wipe out all of the Supreme Court's abortion jurisprudence all the way back to Roe. And Kennedy didn't sign that. So it seems like Kennedy's view was, yes, I'm still on this side for the idea of undue burden as the basis, but not as applied to the partial birth abortion. So they struck down the Nebraska statute, as I said, but then President Bush comes into office, and the now Republican Congress passes a new version of the Nebraska statute. President Bush, whereas President Clinton had vetoed those bills, President Bush signs it. It gets litigated in the lower courts. It gets struck down because it seems to contradict what had been decided by the court in 2000. But it works its way up to the Supreme Court. And now, as I said, we have a majority of 5 because Sandra Day O'Connor has gone and has been replaced by Alito, and Rehnquist has been replaced by Roberts. So that's the history of what happened. But now let's just talk about why it happened a little bit and compare. I want to suggest a comparison between Roe versus Wade and Brown versus Board of Education to see 2 very radically different ways in which the courts approach controversial questions. And this may or may not have some relevance for the Mexican debate. If you go back to Brown versus Board of Education, which the court handed down in 1954, this was the case in which they said that Southern schools cannot be segregated by race. Prior to that, the courts had accepted a doctrine of separate but equal, where it was said that if blacks had somehow equal education to whites, we could have separate schools by race. In 1954, the court said no, separate but equal is impossible, and this racial segregation of the schools is unacceptable. Of course, in 1954, the court had largely been packed by President Roosevelt. He had put 5 people on the court, and Truman had put 3. So the only judge appointed by a Republican was Warren Burger, who was the new Chief Justice who had been appointed by Dwight Eisenhower in 1953, the year before. And Eisenhower had thought he was appointing a conservative. Earl Warren had been a Republican governor of California prior to that. But Warren turned out to be one of the most liberal Supreme Court justices in the history of the court. Some people point to that as an example of the fact that justices don't necessarily reflect the ideology of the presidents who appoint them. In fact, it's really the exception that proves the rule. Most of the time they do. Most of the time they deliver exactly what the president who appoints them wants. That's what now Roberts and Alito are doing, for example. But in any event, Warren put together a unanimous court, 9-0 decision, and he wanted a unanimous court because it was so controversial. He thought that unless it could get a unanimous court, it was far from clear that its opinion would be enforced. It was far from clear that there wasn't going to be civil war breaking out over this decision, and it wasn't clear what the Eisenhower administration would do. So Warren thought it was tremendously important to get a unanimous court. So why do I bring this up in the context of the abortion debate? The reason I bring it up is that there was a radically different approach. In Brown versus Board of Education, the court said separate but equal is unacceptable. It didn't say what would be acceptable. It didn't sit down and write its own statute about how the Southern schools should be regulated or governed. Right? In Roe versus Wade, as we saw, Blackmun wrote down a little statute of his own, his 3-time essay test and so on, and the court got accused of being involved in legislating. In Brown, they said, separate but is equal is no good. You can't do it. You try something else and we'll tell you if it's okay or not. Yeah.
That separate but equal was not an adequate level, and that for some reason it's proved that by being separate, blacks didn't have access to schools with whites, intelligence, and preparation.
Well, there was, if you go and read the Brown decision, they talk about psychological evidence of this being harmful to black children and so on. But it's very unclear, if you read the opinion closely, whether the finding is dependent on the psychological claims or not. But they say separate but equal is inherently unequal. And of course, the black schools in the South have been vastly inferior to the white schools. So, but they didn't give them the option of saying, well, you've got to make them genuinely equal. They just said separate but equal is not an acceptable basis for education.
Raised in Hawaii.
Yeah. So they struck down these rules, but they didn't say what the rule should be. Okay, and they said you go and find it out in your own legislatures, and you figure out how to run the schools, but you can't do separate but equal. So the equivalent in Roe versus Wade would have been if Blackmun had said this Texas abortion statute is unconstitutional, and nothing more. And turned it back to the Texas legislature to see if some other less restrictive abortion regulation would be upheld. Okay, and so why did they do that? They were, as I said, in Brown, they were very afraid for their own legitimacy. They thought this decision might not be enforced. So they saw themselves as doing something that was not a threat to, wouldn't be perceived as a threat to democracy, because they were putting it back in the hands of the legislature. They were saying, this is the outer limits. You can't cross this line. But this still should be a question decided in the state legislatures, and we'll let you do that. The fact that it would provoke more litigation wasn't a bad thing from that point of view. It was a good thing. Because, better that people are going back and forth between the legislature and the courts trying to figure out how to regulate education or what an undue burden on a woman is than having a civil war or fighting in the streets. So it's a mechanism for managing political conflict that the court keeps throwing it back to the legislature and getting people to participate in trying to find an acceptable regime for controlling the schools or for dealing with the tensions around abortion.
But then with busing, you have even more conflict.
You had a lot of conflict, and but much of it was managed through the legislatures, not through the courts. Sometimes courts ordered busing, sometimes they didn't. And sometimes when courts ordered busing, it was upheld higher up, and sometimes it was not. Okay? But so this was a very messy politics on a very controversial issue. But the suggestion is the court would have done better preserving its legitimacy if in Roe versus Wade they had done something analogous. Now, interestingly, in the move from the trimester test to the undue burden test, the courts moved to a much more Brown-like posture, because now there's a lot of unclarity about what counts as an undue burden. It puts it back in the hands of the legislatures to figure that out, and it will come up to the court every so often. For instance, as it did over the matter of partial birth abortion. So the suggestion is that the court enhances its legitimacy. Brown versus Board of Education has widely been seen as a magisterial decision that exemplifies the American Constitutional Court doing its work well, whereas Roe versus Wade has never been seen as a good decision by the court. It's been seen as a kind of imperialist, overreaching, inventing this right to privacy, writing the statute, doing what legislatures should do, and so on. So, one hypothesis one could put out there is that when courts act more as they did in the Brown litigation, they preserve their legitimacy better than if they act as they acted in Roe versus Wade. Let me end with a few remarks about the why question, about the jurisprudential basis. I already mentioned that the term privacy is not in the American Constitution anywhere, and Blackmun's decision was roundly attacked as terrible, a terrible piece of legal reasoning from the beginning for that reason. Now, it's interesting that in 1991, Ruth Bader Ginsburg, who was not yet on the Supreme Court, made a speech at NYU Law School in which she pointed out that they could have made an equality argument all along. They could have appealed to equal protection as the basis for the woman's right to abortion, which of course is mentioned in the Constitution, and which lends itself actually very well to this idea of undue burden, because if people should be subjected to equal protection of the laws, making women unnecessarily bear a burden that men don't have to bear violates equal protection. So the argument could have been. So there could have been an alternative equality-based jurisprudence of abortion all along, and arguably the court has inched towards that in its undue burden jurisprudence. And indeed, if you look at the opinions in Casey in particular, you find a lot of equality language in there, which suggests that the reasoning behind is increasingly like that. However, that's not what the court did. The court in Casey appealed to the doctrine of stare decisis. The opening line of Justice O'Connor's opinion is, liberty finds no refuge in a jurisprudence of doubt. And this is the idea of stare decisis, as I'm sure you all know, is the idea that, well, we might not agree with the basis for a legal decision. We might not be of the view that if we had been there in 1973, we would have made this decision. But it was made. It's been around for more than 2 decades, and we're just not going to go into the question of whether it should have been decided on the basis of privacy, equality, or something else. We're just not going to deal with that question. We're just going to invoke the doctrine of stare decisis, say this is settled law, and we're going to take it from there. So that's what the court, in fact, did. So we have now these three. We have the rather discredited privacy argument that goes all the way back to Griswold versus Connecticut. We have the equality argument that Ginsburg was pushing, and other commentators on abortion jurisprudence have argued would have been a much better basis for the abortion decision. And we have the legal reality of stare decisis, which is, since 1992, has been the actual court's position on what the jurisprudential basis for the abortion decision is. It's, we won't ask. We won't ask. So just in terms of summing up, let me talk about the things to watch. One, obviously, is Kennedy, because he has affirmed this idea of undue burden, but the only time the court ever applied it, he said it didn't apply. So we don't know what he seems to have affirmed. As I said, he avoided signing the dissent of Rehnquist, Scalia, and Thomas. So he still seems to be attached to some version of the notion of undue burden. But as the opinions on the other side said, it's very hard to make sense of an idea of undue burden if it includes saying that a woman could have to undergo a less safe procedure when a more safe one is available. So we don't really know what undue burden means to Kennedy, and therefore that is unpredictable. But the second thing we don't know is what Roberts and Alito believe, because in the 2007 decision, in the decision last summer, Scalia wrote a dissent, which Thomas signed, which was the standard thing they always write in all of these decisions. They say, this is all claptrap. We should never have gotten into this in the first place. Roe versus Wade should be overturned. That's what we should be doing, which, as I said, they always would write those opinions, those dissents or concurring opinions, Scalia and Thomas. And Rehnquist always signed them as well. Rehnquist is now gone. Neither Roberts nor Alito signed that dissent. I should say that concurrence of Thomas and Scalia's. So we don't know what they think. We don't know whether they are of the view that Kennedy is of, that undue burden is fine, stare decisis is fine, and it just doesn't apply to partial birth abortion. Or perhaps they have a more radical view, but they don't want to show their hand yet. Perhaps they agree with Scalia and Thomas that really the whole thing should be done away with, but they don't want to tip their hand yet because perhaps they don't have a majority yet for that view. We just don't know. And maybe they haven't made up their minds, or maybe they want to have it as a chip to play in some other negotiation on the court on some other question. We simply don't know. And we don't even know whether they would have the same views as one another. All of that makes the question of who gets to replace Stevens tremendously important, because Stevens is now 88 years old. And though he was appointed by President Ford, he, along with Earl Warren, is one of the other few exceptions that proves the rule. He's arguably one of the most liberal justices on the court today. But if it turned out that President McCain got to replace Stevens, and it turned out that Alito and Roberts do in fact agree with the conservatives on the court, Scalia and Thomas, then you would have a solid majority, not just for tinkering with abortion regulations, but with the complete repeal of Roe versus Wade and the end of the woman's constitutionally protected right to abortion. Why don't I stop there and we can open it up for discussion?
Thank you very much. Thank you very much, Professor Hill, for your very clear and informative remarks about the politics of abortion in the United States. Well, I'm sure my colleagues here will have comments and questions of their own. You may make your comment or question in Spanish, and if you are unsure about doing it in English, and then perhaps Gustavo and myself will try to translate.
Yeah. I'm not a specialist in abortion law, but I'm interested in the triangulation possibilities that could have come about for the Republicans. Did the Republicans ever try triangulation with the abortion subject so that Clinton wouldn't have been reelected in '96? Or was the subject too extreme for them to even try a certain triangulation and get some of the center votes on their side? Center for the Democrats in this case.
Abortion is a bad electoral topic for Republicans because it's very important in primaries for them, because the Republican activist base is very strongly anti-abortion. But the votes Republicans have to win in the national elections in order to win have to include a lot of pro-choice votes. So, for instance, if you look at Republican platforms that are written at the nominating convention, which are always dominated by the activists, they are resolutely anti-abortion, that Roe should be completely overturned and abortion should be made illegal. That's invariably the abortion plank in Republican platforms. And then when it comes to the general election, the candidates have to run away from that because they can't win if they can't get pro-choice women to vote for them, who are conservative on other issues. So it's not a good electoral issue for Republicans. It's actually a much better electoral issue for Democrats, because it's a way in which Democrats can easily get independents to vote for them, and there are a lot of conservative women who vote Democratic in presidential elections just because of the abortion question. Now, it's an interesting fact that it's a huge missed opportunity, I think, by the current Democrats who are running, that they're not talking about Stevens and abortion, because they feel, well, they've been burned over this partial birth thing, that there was quite a lot of support for outlawing. There was a very good advertising campaign by the pro-life people showing all the blood and gore of partial birth abortions, and actually a lot of untrue statements most partial birth abortions are second trimester abortions. They're not late-term abortions, but there were all these pictures of children about to be born who were being delivered. And so American public opinion is generally strongly pro-choice, but there was a lot of support for this partial birth decision. It was quite popular. So I think Democrats wrongly believe that this is not such a great issue for them anymore. On the Democratic side, there is, but it's not a good electoral issue for Republicans.
Well, I'm not sure if my colleagues would agree. I have a feeling that here in Mexico, the two different camps of opinion, pro-choice and pro-life, as usual, are completely separated. But the arguments, especially the pro-life section, apparently are taking more and more importance in this debate and in these previous hearings that the government are about to listen to the next couple more weeks. I don't know if these arguments, the unsupported arguments, were seen as arguments in between the two camps, because I have the feeling that there, our opinions could at least have a point of reaching maybe agreements that could be useful in order to protect the mother, or in order to protect Spanish life. But I have the impression that in Mexico there are two very separated camps, and as long as we don't get to find those links between the extremes, the decision is going to be or at least this first decision about abortion, the first relevant decision about abortion, is going to be completely either Roe versus Wade, that the idea of absolute privacy of the woman, which I would be kind of surprised, or the other extreme, the argument of life. So, can you tell us if also at that time, a way of finding So that's a very interesting and complicated subject. In the U.S., there's a real disjunction between how this issue is perceived in public opinion and popular discourse on the one hand, and how this issue is seen in the court. Because no justice on the court has ever embraced the view that the fetus is a person, a human being, within the meaning of the 14th Amendment. So, none of the North Korea, not Rehnquist. At one point, in one footnote, Thomas flirts with this idea, but he
backs away from it pretty quickly. So nobody has ever taken seriously the view on the court that the fetus is a human being deserving of constitutional protection. What the conservatives said all along, and what Scalia still says, and what was Rehnquist, this is a states' rights question, that the Supreme Court simply shouldn't be in the business of abortion regulation. So it should have been left up to the state of Texas, up to the state of Nebraska, up to all of these states to do it for themselves. The Constitution does not license the court to get involved in this question. So if the state of Texas were to create a right to life and give it, protections, then the courts would have to enforce it. But absent that, there's no constitutional right to life. Okay, the view is Roe versus Wade should be repealed, finished. So that would suggest now we should turn it back to the states. This is why the pro-life people felt so betrayed by Casey, because they thought they had won in Webster. As when Blackmun said, "This is terrible. My life's work has been destroyed," and Scalia said, "What are you guys messing around with here? You effectively have taken away Roe. Why don't you admit it?" The pro-life people were furious because they thought that the court was coming around to recognizing a constitutional, something much more radical. So the undue burden standard is not a kind of compromise between the pro-life and the pro-choice camps out in the world. It's a compromise between the pro-life and the pro-choice camps on the court, but they have very different commitments. And I don't know if that's the same thing is true in Mexico. I should just add, though, it's now become there's another layer of complexity because after 2000, the national government got into the act. Congress passed a law which President Bush signed and which has been upheld in 2007 by the court. So now there's also a supremacy clause question. For the first time, there's now national abortion legislation, which there never was, which will, I think, further complicate things for conservatives on the courts because of the states' rights versus federal government issues involved that have nothing to do with abortion, but which were not litigated in the 2007 case, but will be in the future. But that's a kind of lot of technical constitutional law questions are going to come up that haven't yet out of future abortion litigation, I think. But generally speaking, the court has never held the view, or even flirted with holding the view that the fetus is a constitutionally protected person. If they did, undue burden would go the other way because the burden put on a woman would not be as severe as the burden of losing your life. So clearly they haven't taken that view. Yeah. Two comments. The first one is sharing a comparative perspective on the first challenge. Yeah. I would say that what is the challenge in the first semester rule, the idea of the decision of the woman to carry an abortion during the first semester, where we are still talking of a non-vital product. So that's what's being challenged. And you can easily see there's the two main arguments are on the local chamber cannot regulate this penal exemption. And the second argument would be like the local chamber is not entitled to regulate health issues, like the procedures, which I would say that's still my understanding of the partial birth abortion of ruling in the 2007 decision seems to be a health argument at some point, not really the decision of the woman to carry an abortion, but more like an issue of health
Some procedures will risk repeal, some procedures are acceptable, some others are not. This is somewhere so much psychological damage into the room, which is carrying the partial law, the birth, and it's so something like that seems to be part of the argument for me. And the final comment will be on the second question. It's related to the contrast between the Crown versus differentiation and the Roe v. Of course, the Warren Court is considered like the most active court in the U.S. But you just pointed out that it was a very narrow way of being active. They were limited only to the negative effect of overruling legislative bill. Whereas in the Roe v. Wade, it was much more active, where the court was drawing lines between the truth and mercies and so on. So it was like somehow a paradox, which you were pointing out by making the parallel between the two decisions, in which the supposedly most activist court is not that activist, whereas the other activist court is, by the same token, it opens all these debates for further legislation and litigation.
Well, on your second question, yes. If you look at the more recent scholarship on school desegregation, read a book called The Hollow Hope by a guy called Jerry Rosenberg, who teaches at the University of Chicago. He makes an overwhelming case that to the extent school desegregation was achieved in the South, it was by legislatures, and the court played this, facilitating role, but it didn't desegregate the Southern schools. So I agree with that. So this whole question of the health of the woman in the two partial birth abortion decisions is quite complicated, and I could explain it, but I don't know if it's really interesting to you. It'll take 5 minutes to explain it. Do you want me to explain it? Okay. So here's the. We all know. I don't know if this is true in Mexico, but in the U.S. Appeals courts are not supposed to consider questions of fact, right? Because they don't hear witnesses. So questions of fact are supposed to be settled by trial courts. There are exceptions, but the exceptions are that the decision has to be at such extreme variance with the facts that no reasonable person could have found factually the way it was below. So by and large, appellate courts are not supposed to consider questions of fact. Well, obviously, the arguments about health are questions of fact, not questions of law. So if you look at the 2000 partial birth abortion decision, there was litigation below on the question of fact. Stenberg came in saying, yes, I'm a physician, and there are circumstances in which a partial birth abortion is less damaging to the health of the mother, and therefore should be allowed. And that view prevailed at trial. That view prevailed. Then, when it was litigated up to the Supreme Court, it was upheld, but both Kennedy, when he switched his view, challenged that. He said he wasn't persuaded. Kennedy was not persuaded about these arguments that it was actually more healthy, less dangerous to a woman's health to allow partial birth abortion. And Scalia and Rehnquist and Thomas also, in their opinion, said they argued with this proposition. Now you could say, well, it was completely irrelevant, because at most you would say if the factual question below was wrongly decided, and it's obvious that it was wrongly decided, it should be remanded for another rehearing on the question of fact below, and they didn't do that. But anyway, they lost, because the Nebraska statute was struck down. Then what happens? Congress gets into the act and passes the Partial Birth Abortion Act, which President Bush signs. And they try and finesse this question in the following way. they hear some testimony about the health effects of partial birth abortion, and they write in the legislation that as a congressional finding, it is never the case that a partial birth abortion is indicated from the point of view of a woman's health. As a congressional finding. Okay. And that's the only difference between the congressional statute and the Nebraska statute. So, the Nebraska statute, O'Connor had said, well, there's no exception for the health of the woman here. Congressional statute, they say, we, the United States Congress, find that there is never a situation when the health of the woman requires this. So then this starts being litigated in the courts below, and again, there's testimony on this question of fact, and people come in and say, well, look at the congressional testimony was ridiculous, that they didn't hear from anyone who had ever performed one of these abortions, that the American College of Obstetricians and Gynecologists is the whole medical profession is clearly of the view that this is sometimes medically indicated. There were things in the bill which said, for instance, no medical school teaches this procedure. This is flatly untrue. All of the major medical schools teach it. So the courts below struck down the federal statute, saying this is clearly at variance with what the court decided in 2000, and these congressional findings are absurd, and there's no basis for them. And the courts below still settled the question of fact on the strike down the statute side. Then it's litigated out. And the Supreme Court says, well, yes, it is riddled with contradictions, and the statute makes these factual assertions which aren't true. But we're just going to say, well, we can't say that if a question is factually controversial, Congress cannot act. And that's the line in the majority opinion. We can't say that if the factual question is uncontroversial, Congress cannot act. But of course, that's a non sequitur, because the question is not whether or not Congress had the right to act, but whether or not the courts below were abusing their role as a trier of questions of fact in saying that the arguments in the congressional statute don't pass muster when put alongside the other factual arguments made at trial. So that's where it stands right now on this question of partial birth abortion and the health of the mother. It's somewhat ambiguous in the majority opinion in the 2007 decision whether the court is saying if Congress in a piece of legislation declares something to be the case, trial courts have to accept that. That seems to be what they're saying, which is a radical statement, but it's hard to square with the result otherwise. But that's sort of where they are now on the health of the mother. On the question of the psychological health of the mother, the centrist bloc of O'Connor, Kennedy, and Suda that created the partial, that created the undue burden standard, they recognized that if you included psychological health as defined by the attending physician, that this would make all abortion regulation meaningless, so they don't buy into that.
Thank you, Dr. That's very, very clear. It's just a comment. Would you say that women's constitutional right to abortion is more a traditional judicial activism issue? Because about Justice Scalia, let me know if
I'm wrong, because I think that he was able to say that the first skill for the interpretation of application was the dictionary. And I think that he was to say that the United States is more a civil country than a powerful country. My question is, the abortion itself and the right to abortion of women, activism, or is more an issue that they prefer that they rather do not touch, do not talk about?
Well, that's Scalia and Thomas are of the view that it should be an issue that the judiciary shouldn't touch. So, is it a matter of is a right to abortion the constitutional right? It's a constitutional right for as long as 5 justices on the Supreme Court exist to say that it's a constitutional right. Now, of course, it can become a constitutional right in other ways. If Roe versus Wade were reversed by the court, some states have decided as a matter of their own state constitution, Connecticut, where I live, for example, the Connecticut Supreme Court has interpreted the Connecticut state constitution to guarantee a woman a right to an abortion. This is where the supremacy clause issues would come up. If suppose McCain wins the election and replaces Stevens with a conservative, and it turns out that Alito and Roberts and the new appointee do agree with Thomas and Scalia, and Roe is the court gets rid of Roe. Then you say, well, what's going to happen in the state of Connecticut, where the Connecticut State Supreme Court has said that the Connecticut state constitution guarantees a woman a right to an abortion. This is where the supremacy clause stuff will come in. Then, so a woman, let's say, goes to have a partial birth abortion, and it'll be litigated because the Supreme Court has upheld a federal law proscribing that, ruling that out. So then the litigation will be, well, so what? This is a states' rights question. The Connecticut state constitution guarantees this right. Who is Congress to interfere? Now, this will be a very hard issue for conservatives on the court, because in many other areas, conservatives are strongly states' rights and trying to push back federal involvement. But so that's one of the future areas. I think if the conservatives win on Roe, that's going to be the kind of area where you're going to see abortion litigation get mixed up with supremacy clause questions. Even if they repeal Roe, it's not clear that you want, at least in some states, have a constitutional right to abortion. Yeah.
Anyone comments and questions?
Hi. Excuse me, my English maybe it's not very good, but I want to ask you.
It's better than my Spanish.
Anyway, I want to ask you two things. The eventual influence of the religion in the United States about this subject, and the second is very subjective. But I don't have confirmed information, but I know that when the American invasion in Vietnam, in Afghanistan, in Iraq, it was trained many women about the American soldiers. And the American soldiers asked abortion in that moment, but the women said no. So they asked some kind of military jurisdiction or a civil jurisdiction, always American, but there is the problem that it's women in other countries. So it's maybe it's a subject not very heard by the public because it's very difficult about the life of the soldiers. But I want to ask you, you can say something about that. Thank you.
Well, the U.S. Supreme Court wouldn't have anything to say about it. It would depend on the law in the country concerned, in the law in Afghanistan and so on. Because if abortion were illegal in such a country and an American soldier got somebody pregnant in that country, it would be the local law of abortion that would be at issue, not anything in American. The only way it could happen is if it were part of something that led to the trial of say there was a rape or something, and a soldier, in addition to whatever happened to them in the local country's legal system, the soldier was subjected to a military trial, a court-martial or something like that, then maybe American courts would somehow get jurisdiction over the matter. But I still don't see how it could possibly have anything to do with abortion. Partly because, in any case, it's never the male who is involved in abortion litigation, except in the only way in which the father has never been involved in abortion litigation is there have been cases where men have tried to prevent women from having their wives from having abortions. The court has systematically said no. The father doesn't have a right to stop the mother having an abortion. So it's difficult for me to see how this issue could ever involve American constitutional law in any way. Well, the religion question cuts both ways because if you look at American Catholics, they're very divided on abortion. They're pro-life and pro-choice, and there's a lot of conflict within the Catholic Church. Yeah.
I read an article about violence in New York and the levels during the government during July's time in New York. So the article says that the levels of violence in that time were not that tall because the generation before were able to have an abortion. In the city it was allowed to have an abortion. But the generations before that generation were prohibited to have the right to abortion, so the level of violence, it was taller in the generation after the abortion was prohibited. So my question is, can the topic of violence as a public policy can be used to support the idea of the abortion right?
Yeah, you're referring to this book called Freakonomics, right? In which there's the case is made that if you look at violent crime in the U.S., it varies with abortion regulation, and that the hypothesis is that the kind of people who would otherwise have had abortions but didn't when abortions were illegal are the kind of people who had the children who, all else equal, are more likely to become criminals later. So that if you really want to, you should be pro-choice as a matter of crime control 20 years from now. This is the implication of this. So this is pretty controversial research, but I don't think it has a lot of impact. You can make up other kinds of arguments. You can say, well, if you really are a religious person who thinks that innocent souls go to hell, you should be pro-abortion because that fetus is go to heaven. That fetus's soul is going to go to heaven because it is innocent. So if you're trying to maximize the number of souls going to heaven, you should be pro-choice. I don't think any of these arguments have any impact at all because we were talking earlier about how the discourse about abortion on the court is very different from the popular discourse about abortion. On the court, nobody thinks they've never debated this question whether a fetus is a person. But in the popular debate, that's all about that, right? So I actually think the popular debate about abortion is really, it's a symbolic issue. It's really about the control of women, the place of women in American society. It's a symbolic issue. It's a kind of marker for people to say they're social conservatives. And, you know, that's completely unaffected by these arguments about crime or heaven or, you know, so I think that the reason, and this may or may not be similar in Mexico, but the reason abortion politics is such an incendiary issue in America, in the popular world, is really, it's really about the control of women. It's really about people being for or against the feminist movement, being for or against women being out of the home, being, you know, it's sort of a proxy for those issues. And so these other debates are very unlikely to have an effect upon it.
I can wait till the lunch.
Well, I think, we are aware that this is not the end of the discussion.
Never the end.
And we really don't know what will happen in Mexico, but your presentation has been really very, very interesting for us. And it sharpens our sense of what is really at stake and the political issues that are behind us. So I would say thank you very much for being here with us, for giving these remarks, and I hope we'll have you in future occasions here when we come to Mexico and discuss other topics that are also very interesting for the legal community, for legal scholars in Mexico. Thank you.
You're welcome.